Okay, hi guys. So today we are going to discuss about the topic constitutional law. It is a very important content in any law entrance exam, or it is also very basic for any competitive exam. So in this section we are going to study about the basic elements in the constitution and the political system. You must have observed or seen that it shall be very easy for you to enter the portals of a law college if you confront and wrestle yourself on this chapter of constitutional law and the political system. Actually, all the laws evolved from the constitution and being implemented in our political system. So this area of study must be paid special attention by the prospective candidates. So we are going to discuss each and every content of the constitutional law. This is the part 1 of constitutional law. In this section we are going to study contents like preamble, citizenship, fundamental rights, executive, legislature, judiciary, all the components related to the constitutional law. So here are the contents which we are going to study in this slide. First is preamble and the citizenship. Preamble is basically a poem-like structure of Indian constitution, and citizenship tells us that who is the citizen of India and who is not. Next content which we are going to study is fundamental rights under the concept constitutional law, executive, legislature, judiciary, emergency provisions, amendments, and yes, the last but not the least, political process. So these are the contents which we are going to study in this video, and the major topics which we are going to cover in this part 1 will be the basic introduction of the constitution, the making of the Indian constitution, constituent assembly, preamble, members of the constituent assembly, women members of the constituent assembly, and the topic related to the citizenship. So as you can see here, it is the preamble of our Indian constitution. The preamble reads as, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly this 26th day of November 1949, to hereby adopt, enact, and give to ourselves this Constitution." So this is the basic preamble of the Indian Constitution. As I stated earlier, preamble is a poem-like structure. It is basically a kind of an index of Indian Constitution. The major ideals and goals of the Indian Constitution are prescribed in this preamble. The idea of justice, social, economic, political have been taken from the Russian Revolution of 1917, and the idea of liberty, equality, fraternity have been taken from the French Revolution, which happened in the years 1784 to 1799. Preamble has been amended only once in the year 1976 by the Constitution as 42nd Amendment Act. The words secular, socialist, integrity were added by the amendment. So in the preamble, if you see the words secular, socialist, integrity, these words have been added once in 1976, and that was the only amendment that has been done to the preamble till date. On the question whether preamble can be amended or not, there has been different cases on which Supreme Court give their hearing, and according to the Supreme Court's decision, the court observed that the edifice of our constitution is based upon the basic elements mentioned in the preamble. If any of these elements are removed, the structure will not survive and it will not be the same constitution. So according to the decision of the Supreme Court, basic features in the preamble cannot be altered. So did you get my point? The basic features in the preamble cannot be altered, and this hearing was given in the case of Nanda Bharti case of 1973. The Supreme Court held that preamble does form a part of the Constitution and observed that the preamble to our Constitution is of extreme importance, and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. Court further held that since the preamble is a part of the Constitution, it can be amended, but it's subjected to the condition that the basic features in the preamble cannot be altered. Making of the Indian Constitution. The Constitution, as you all know, is a set of laws and rules setting upon the machinery of the government of a state or a country, which defines and determines the relationship between different institutions and areas of government, that is executive, legislature, judiciary, central, regional, local government. In a nutshell, we can conclude that citizen is a compact document in which our written rules and regulations are prescribed on the basis that minimal coordination in the society should be achieved between all the members. So we are going to study that how was the Indian Constitution made and under what provision Indian Constitution worked. So, the Constitution of India was framed by the Constituent Assembly set up in 1946 under the Cabinet Mission Plan. I have already added the previous video on the concept Cabinet Mission Plan. You all can have a look there. And under this plan, the total strength of the Constituent Assembly was to be 389, out of which 296 were to represent British India and 93 were to represent princely states. Further, out of 296 members, 292 were to be elected by provincial legislatures and 4 members were to be drawn from the Chief Commissioner's provinces. These Chief Commissioner provinces were Ajmer, Delhi, Coorg and Balochistan. I am repeating the names again: Ajmer, Delhi, Coorg and Balochistan. Total seats occupied by Congress were 208. Total seats occupied by Congress were 208 and seats occupied by Muslim League were 73. Other seats were 15, which were occupied by different sections of the community and the society. After the election, Muslim League refused to cooperate with the Congress and the political situation got worse. Hindu-Muslim riots started. Muslim League demanded a separate constituent assembly for Muslims in India. Also, to add one more point here, the difference between princely states and provinces is that provinces were ruled by Britishers. They were ruled by British government, hence they were also called as British India. Princely states were those were ruled by the princes, the Maharajas, the kings at that time. So guys, I don't want this video to be a monologue for all of you. I want you guys to interact while I'm asking questions in this video as well. So actually on 3rd June, as I stated in my previous slide, the Hindu-Muslim riots got started and the Muslim League demanded a separate constituent assembly for Muslims in India. So according to Lord Mountbatten's 3rd June 1947 proposal, he announced his intention to scrap the Cabinet Mission Plan, and this resulted into the Indian Independence Act of 1947. So my question here is that according to Indian Independence Act, what happened in India other than the independence granted to Indians? What happened other than the independence granted to the Indians? The answer to this question is very simple. Yes, the partition of India into 2 dominion nations were held. That is, British India got divided into 2 parts, India and Pakistan. As a result of the partition under the Mountbatten Plan of 3rd June 1947, mark the dates guys, these dates are very important. You have to remember the dates and the year. On 3rd June 1947, a separate constituent assembly for Pakistan, and representatives of some provinces ceased to be the members of the Constituent Assembly of India. As a result, so the point here lies is that as a result, the membership of the Indian Constituent Assembly was reduced to 299, out of which 229 represented British Indian provinces and 70 represented princely states. So the number got reduced to 229 representing British Indian states and 70 representing princely states after the Mountbatten Plan of 3rd June 1947. So the next point states that the Constituent Assembly held its first meeting on 9th December 1946, where Dr. Sachidanand Sinha, the oldest member of the Assembly, was elected as the temporary president till the permanent president is elected. So the first session was attended by 207 members, including 9 women. You have to remember this, guys, that the first session was attended by 207 members, including 9 women. And on December 11, 1946, Dr. Rajendra Prasad was elected as the president of the Constituent Assembly, and H.C. Mukherjee was elected as the vice president of the Constituent Assembly. On 13th December, right after 2 days, on 13th December 1946, Jawaharlal Nehru moved the objective resolution in the Assembly, under which certain objectives related to Indian Constitution were prescribed, like to make India to be a sovereign republic, to establish India as democratic union, all the powers and authorities of central government and state government to be derived from the people, to maintain integrity, to provide adequate safeguards for minorities and backward sections, to have India a rightful, honored and dignified place in world platform, to contribute to the promotion of international peace and security. So these were the basic ideals which were involved in the concept of objective resolution, which was a proposal being moved by Jawaharlal Nehru on 13th December 1946. And finally, the Constituent Assembly adopted these resolutions on January 22nd, 1947. So this topic is related to committees of the Constituent Assembly. In most of the competitive exams and in the law entrance exams, these committees of the Constituent Assembly are vital important concept which is supposed to be studied by all of us. So the Constituent Assembly appointed 22 committees to deal with different levels and different tasks of the constitution making. We are going to study the major committees and who were their chairperson. Actually, the committees were divided into 2 sections, substantive affairs and procedural affairs. So as I stated, the committees of constitution making were into 2 parts. One was substantive affairs and the another one was procedural affairs. There were total 22 committees, out of which 12 were on substantive affairs and 10 on procedural affairs. So we are going to study about the major committees here. First one is drafting committee. It was formed on August 29, 1947. The chairperson of the drafting committee was Dr. B.R. Ambedkar. There were 7 members. First one was Dr. B.R. Ambedkar. You can jot down the names of the members. I am highlighting over here. Dr. B.R. Ambedkar, K.M. Munshi, Alladi Krishna Swami Iyer, N. Gopalaswamy Iyengar, Sayyid Muhammad Saddullah, N. Madhava Rao, T.T. Krishnamachari. The 2 members which I stated in the last, that is N. Madhava Rao and T.T. Krishnamachari, were replaced by B.L. Mittal and D.P. Khaitan respectively. B.L. Mittal and D.P. Khaitan respectively. So this was about drafting committee. Then there was another committee called as Union Powers Committee, and its chairperson was Jawaharlal Nehru. Then the another committee was Union Constitution Committee. Its chairperson was also Jawaharlal Nehru. Another important committee was Provincial Constitution Committee, and its chairperson was Vallabhbhai Patel. Another important committee was Advisory Committee on Fundamental Rights, Minorities and Tribal and Excluded Areas. This advisory committee has 4 subcommittees, and its chairperson was Vallabhbhai Patel. Then the next major committee was Committee for Negotiating with States, and its chairperson was also Jawaharlal Nehru. Then there was this special committee set up to examine the draft constitution, and its chairperson was Alladi Krishnaswamy Iyer. Then there was this ad hoc committee on national flag, which was headed by Dr. Rajendra Prasad. So in the next section, now we are going to see the 15 women members who participated in the Constituent Assembly of India. The names are very important from examination point of view. If you are appearing for any law entrance exam or any other competitive exam like UGC NET or UPSC, the name of 15 women members of Constituent Assembly are very important to be studied. So, here are the names of 15 women who were the part of the Constituent Assembly of India. First one is Ammu Swaminathan. Second is Annie Mascarene. Third is Begum Ejaz Rasul. Fourth is Dakshyani Velayudan. Fifth is Durgabai Deshmukh. Sixth is Hansa Mehta. Seventh is Purnima Banerjee. Eighth is Renuka Ray. Ninth is Sarojini Naidu. 10th is Vijay Lakshmi Pandit. 11th is Sucheta Kripalani. 12th is Rajkumari Amrit Kaur. 13th is Malati Chaudhary. 14th is Kamla Chaudhary. 15th is Leela Ray. So these were the 15 women who were the member of Constituent Assembly of India, which was responsible for the making of Indian Constitution. So from examination point of view, the sessions of the Constituent Assembly and the basic information regarding this assembly is also very important. There were actually 11 sessions which took place, and Constituent Assembly met on different dates to debate, discuss and deliberate upon various issues that were responsible in the procedure of the constitution making. The first session was held between 9 to 23rd December 1946. The second session was held between 20th to 25 January 1947. The third session was held between 28th April to 2nd of May 1947. Fourth session was held between 14 to 31 July 1947. And fifth session was held between 14 to 30th August 1947. The sixth session was held on 27 January 1948. The seventh session was held between 4th November 1948 to 8th of January 1949. The eighth session was held between 16 May to 16 June 1949. The ninth session was held between 30th July to 18th September 1949. The 10th session was held between 6th to 17th of October 1949, and the last and 11th session was held between 14th to 26th of November 1949. The drafting committee prepared the first draft of the constitution after taking into account the proposals of the various committees. It was published on Mark the date. The drafting committee published its draft on 21st February 1948. So the draft constitution for the very first time was published on 21st February 1948, and it contained 315 articles, 8 schedules at that time, and people of India were given 8 months to discuss the draft and propose amendments over it. The draft constitution was considered for 114 days. Yes, 114 days. ड्राफ्ट कॉन्स्टिट्यूशन को बनने में 114 दिन लगे. The Constituent Assembly adopted the national flag on 22nd July 1947. We adopted national anthem and national song on 24th of January 1950. There was this provincial parliament, or you can call it as interim government, which existed till April 17, 1952, and at the day of 26 November 1949, 284 members signed the document which is called as the Constitution of India, and on the day of 26 November 1949, the constitution was consisted of total 395 articles, which were divided into 22 parts and 8 schedules. Yes, you heard it right. 395 articles, 22 parts and 8 schedules. For your kind information, at present the article number is 395 and the last numbered part is 22. Yet the actual articles are somewhat around 450 in number, and it is divided into 25 parts and contain 12 schedules. Whenever a question is asked in any competitive examination that how many articles are there in the constitution, then you have to answer 395. Yes, you heard it right. Then you have to answer 395. Not like any other number 450, 456, 464, etc. Because in present and in actual there were 395 articles which were added into the constitution. Yes, the number of articles and the schedules have been increased, but that is because of the amendment portion. The real number of articles which were adopted on the day of 26th of November 1949 were 395 articles. On this day, we adopted articles like 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 389, 388, 391, 392, 393 and 394. So these were the articles that came into force on the day of 26th November 1949. We also call this day as the Law Day. And other articles of Constitution came into force on 26th January 1950. Overall, the Constituent Assembly held 11 sessions as we just studied, and the Assembly met for 2 years, 11 months and 18 days to complete its task of drafting the Constitution. So the nature and territory of India, under this topic, Article 1 is being discussed, which states that India or Bharat shall be a union of states, and at present there are 28 states and 9 union territories. Why union territories are 9? Anybody knows that why 9 union territories have been stated here? Because recently Jammu, Kashmir and Ladakh were called as 2 separate union territories, and now there are no 29 states anymore, because one state has been removed from the list of states, and that is Jammu Kashmir. As I just told you that Jammu Kashmir has been made the union territory of India. while Ladakh has also been created as a union territory of India. So at present, India has 28 states and 9 union territories. There is a difference between Union of India and the Territory of India. The expression Union of India includes only the states which enjoy the status of being members of the federal system and enjoy the same power of union government, while the Territory of India talks about the territories of the states, union territories, and the territories which have been acquired from time to time. So, our Indian constitution and Indian government is based on the system of semi federalism, which is also being called as quasi federal. From examination point of view, this topic is also very important. That's why I have included it in the lecture. It is called as citizenship. The constitution provides for the idea of citizenship, that who is a citizen of India and who is being terminated from the citizenship and who cannot be called as the citizen of India. So there are different acts related to the citizenship. We are going to study it in the next slide. The Indian constitution provides for the single and uniform citizenship for the whole of the India, and the rights of the Indian citizens, that who is an Indian citizen, because they enjoy specific rights. And what are those rights? Those rights are fundamental rights, हमारे मौलिक अधिकार, and the privileges to officers such as those of the president, vice president, judge of the Supreme Court or a high court, or attorney general, governor. All these privileges to the officers are given if you are an Indian citizen. And also, the Indian citizen has the right to vote, the right to become a member of the parliament and the state legislature. So this was your lecture on constitutional law, part 1. We have just studied the concepts of making of Indian constitution, preamble, name and territory of India, its nature, citizenship, different committees being set up by Constituent Assembly, and general information about the making of the Indian constitution. Now in the further part of the lecture, we will be studying about the concepts like fundamental rights, political process, emergency provision, union judiciary, union legislature, union executive, state legislature, state judiciary, and most importantly, the amendments to the Indian constitution. So in order to study further, keep following, sharing, subscribing and liking it. And if you do have any feedbacks are most welcome here. Thank you for your precious time.